Welcome to another episode of Quick Counsel with Kristen Lavoie and Aaron Van Kampen, where we provide you with a practice tip or an overview of a legal issue in just a few minutes. I'm Aaron, and today I'm going to talk to you about the Michigan Supreme Court and some current pending issues. What does it mean for a case to be pending in the Michigan Supreme Court? Well, it means one of two things. Either that the Michigan Supreme Court has granted leave to appeal, which we sometimes call a leave grant, or that the court has granted mini oral argument on the application, which is sometimes called mini orals or a MOA. Regardless of whether it's a leave grant or a MOA, in both cases, the parties will provide additional briefing to the court addressing the arguments on the issues the court is concerned with. The court will also hold oral argument. In the case of a leave grant, the court will decide the case with an opinion by the end of its term, and its term ends, this current term ends, on July 31st, 2026. For a MOA, the court has more options for how to resolve the case. The court can and often does issue an opinion deciding the case. Sometimes the court decides the issue by order with some reasoned analysis, but much less detail than an opinion. But the court is also free to grant leave to appeal and have additional briefing and argument, or to deny the application for leave to appeal at that point, in which case the lower court's decision stays intact. As part of this practice tip, I've prepared a list of the pending issues in the current Michigan Supreme Court term. That's available with the QR code here. And each of those cases mentioned in that handout includes a link to the court's website. The court keeps a web page for each case that's pending before it, where it's either granted leave or a MOA. And those pages are a great resource because they include the court's grant order, they include the lower court's opinions, they include the parties' briefs, and they will eventually include the Supreme Court's opinion. So let's talk about some pending issues. On the issue of discovery, the court is going to consider the showing required for in-camera review of privileged records. This is sometimes called a Stanaway issue. When it comes to suppression issues, the court is considering in two separate cases the validity of Miranda waivers and the subsequent statements made after arguably defective waivers. The court is also going to be considering whether probable cause of a civil infraction can justify the police in searching a car for evidence of that civil infraction, whether a warrant is required to test the clothing that someone is wearing at the time of their arrest, whether the nexus requirement for a search warrant can be based just on ongoing drug activity, even if it's not tied to the location to be searched. So those are some suppression issues that we can expect decisions on in the months ahead. When it comes to the issue of pretrial delays, this is an area where we don't get a lot of case law development, but the court has actually granted and ordered argument and briefing on the issue of the appropriate analysis and potential remedy for an initial arraignment delay. And the court has granted on a speedy trial issue, so we may see some good case law in this arena yet. When it comes to legal defenses, the court is taking up the issue of entrapment and considering what the appropriate standard to be applied is at an entrapment hearing, as well as on appellate review. The court is also considering issues related to causation in traffic cases, right? So these are the driving causing death type cases and the issues of proximate cause that can come up with them. The court is also relatedly considering whether and under what circumstances evidence of a victim's blood alcohol level can be admissible as part of that causation defense. The court is, again, considering whether it should overrule People versus Carpenter, which eliminated diminished capacity as a potential defense in Michigan. And so we are cautiously optimistic we will get a decision from this court in the months ahead that will allow people to litigate diminished capacity as a defense once again. And finally, the court is also considering under what circumstances defense counsel might be able to concede a client's guilt of a lesser offense as part of a strategy. When it comes to evidentiary issues, the big one is that the court is considering whether a diagnosis termed as medical torture is one that expert is allowed to testify about at trial, given concerns that it might invade the province of the jury because of the way that the terms of that diagnosis incorporate legal standards and legal terms, right? Because torture is a term of art and one that is defined by our statutes. There's some concern that experts giving opinions like this might override the jury's sort of, role as fact finder and entity that is supposed to make those determinations. In the arena of sentencing, the court is considering cases involving issues with OV3 and OV15. On the OV15 issue, they're specifically considering whether, and that's the offense variable that is scored based on indications of drug trafficking. The court is specifically considering whether that is a variable that is limited to the conduct underlying the sentencing offense, or if it can be based on conduct related to dismissed or even uncharged um, uh, drug trafficking activity. When it comes to SORA, the court is considering arguments that the lifetime registration requirements baked into SORA for certain offenses, and whether the lifetime electronic monitoring requirements that are also included in SORA, whether those violate Michigan's prohibition on cruel or unusual punishment, or the Eighth Amendment of the United States Constitution. The court is also considering whether SORA's recapture provision violates those same constitutional principles, as well as whether that recapture provision is one that triggers or violates ex post facto rights. In addition, in terms of economic penalties, the court is going to be considering whether and under what circumstances courts are allowed to impose costs for attorney fees on the accused, particularly when the accused is an indigent person. This grant order is an interesting one because it also is going to it asks the parties to address the MIDC and the fact that the MIDC now exists and how that might affect the court's ability to impose attorney fees as authorized by the statutes that pre-existed the MIDC. So we'll see what happens there. Restitution hearings. The court is considering whether restitution can be ordered for future lost earnings of a deceased victim. And then in the juvenile life arena, so here we're talking about young people, sometimes young people as old as 20 years old, who are, sentenced to serve long sentences. The court is continuing to address issues related to, what categories of people are entitled to those sentencing benefits and what kinds of sentences can be appropriate for young people convicted of serious capital crimes, often homicide, and also the procedural rights those people might have in resentencing hearings. So the court is going to be considering whether the government can compel an individual being resentenced under Miller, Montgomery, and that line of cases, whether the government can compel them to undergo a psych eval, and if so, under what circumstances. And the court is also going to be considering whether a sentence of 50 to 75 years in prison is cruel and or unusual when imposed on a juvenile. So this is what we sometimes call de facto life sentences because the minimum sentence is so long that it exceeds the young person's life expectancy, at least, based on life expectancies for people who spend most of their lives in prison. So what do you do with these pending issues? It's good to be aware of them because you might have a case where it makes sense to preserve one of those issues, even though you don't know yet how the court is going to decide it. And if your goal is just to preserve the issue so your client can benefit from that on appeal if the Supreme Court's decision comes down their way, then all you really need to do is make an objection or file a pretty simple motion telling the court that you're asserting that your client has this right and that while maybe the existing case law isn't on your client's side, the issue is pending in the Michigan Supreme Court and you are preserving that issue for purposes of appellate review. Now, in some cases, if that issue is central to your client's case, and especially if it's consistent with your client's goals, this, can depend a lot on whether your client's in custody, you might want to consider asking the court to adjourn the trial, to await the court's decision if it's likely to have that big of an impact on the case. And finally, in the appropriate case, you might want to just try to convince the trial court that the Michigan Supreme Court will ultimately issue an opinion favorable to your client, and so the trial court should make that ruling themselves as well. You're going to have your best luck with this tact if the case law is not adverse to your position at this point in time. And this is a situation where looking at those websites, web pages posted by the court for each of the pending cases is going to be especially important because the parties' briefs are available on those web pages, and you can look to the parties' briefs to get an idea of how you might want to frame and litigate the issues in your case in your trial court pleadings. I hope this has been a helpful overview of what to look for in the months ahead from the Michigan Supreme Court and helps you think about some issues to start either preserving or litigating in your cases. If you're interested in a lot more detail about the decisions that have been issued by the Michigan Supreme Court and the Court of Appeals over the past year, check out the Case Law Update, which is one of many recorded trainings available to you and eligible for CLE on WayneCountyDefenderTraining.com, or you can use the QR code on your screen.